Ja, god morgen alle sammen.
Good morning, everyone. I have made a presentation which is a lot longer than my allocated speaking time, so we'll look at the different cases as we proceed, and then you can go back to the details later. I've listed this from Norway to try and look at the different themes in particular. And I'm going to start by dealing with the Court of Appeals level, unless it's relevant to start at the first court of law. And first, we have a case where an entire universe has been set up for a concept. Flåklypa is a society which was set up in Humor Chronicles back in 1954, where Kjell Aukrust worked at a newspaper. And he developed a number of very imaginative creatures who lived in Flåklypa. Reodor Felgen, who's a bike repairman, Solan Gunnarsson, Pinnsvin Ludvig, and dairy assistant Emanuel Desperados, a whole set of characters. With Caprino film centers and a family park signed an agreement, and since the summer of 2014 this amusement park have offered a roller coaster ride called Il Tempo Extra Gigante. You can see a picture of it here, and this roller coaster is based on a license from the Aukrust Foundation, and they say that this is a processing of the Flåklypa Grand Prix movie, which Kjell Aukrust and Flåklypa made in 1975. They say that they have processing rights for these pictures and that the roller coaster therefore is an unlicensed adaptation, and so an infringement therefore of the original rights. And here I'll show you some pictures of the different processing images that are under dispute. The first court instance came to the conclusion that it was not an infringement, in fact, of the Caprino Film Center rights. Under a license to the Court of Appeal came to the opposing result. They determined that there is the copyright to drawing A, and that the film is a processing of this picture under, or this drawing under A, or other racing cars where Aukrust holds the copyright. And they're also saying in the Court of Appeal that Santamoso, who built this the rights that they had for building it and producing it have been transferred, and therefore it is the movie car which is the processing of drawing A, and therefore is an infringement. It has been appealed against on the 17th to the 19th of October of this year. It will be dealt with in the Supreme Court. I have, at the Supreme instance, I have some thoughts about this to consider. The Court of Appeals have made an overall assessment to say that the roller coaster is providing an infringement of the processing rights. And so the question is whether, or rather how, the court has processed with this assessment. And the holistic assessment performed by the court, does it also include the original drawing of Aukrust, which the car is then based upon? The court says that it is a processing of drawing A, and in order for the movie car to also be an infringement, it has to also be linked to the original Aukrust rights. My question here is whether the court can really perform such a holistic overall assessment without the original drawing of Aukrust being included in that assessment. And should they not focus on them before they focus on whether the Caprino rights have been infringed against in the roller coaster? I cannot find that they have assessed this prior situation, and therefore I feel that the assessment is incorrect. Furthermore, shouldn't the conclusion of the court be such that the right holder is in danger when licensing rights, in that the license holders can exclude the original situation and prevent the further own use of the universe? It's going to be very exciting indeed, I have to say, to hear what the Supreme Court instance will conclude. It's very important to get the clarification on the right to this universe. Furthermore, next case deals with photographs in a digital museum. I can't go into all of the details. Suffice it to say that Norsk Folkemuseum won the case, and it was determined on the basis on the photography law and the commissioning rights, and not on the basis of copyright legislation in that particular case. We've also had a copy of a bathtub in a case where the original right holder to this Dutch tub won against a copier, Haitu Potter, and you can read more about that in my presentation. I'll refer you to that for more detail. And the next theme I thought I'd talk about are matters pertaining to the right to make available various documents, etc. This case deals with distribution of a very large number of photos which were illegally downloaded from Facebook, from Snapchat, and from Instagram, and distributed to a network. In the Supreme Court level, they went further than the Court of Appeals instance, ruling that in a preventive ambition, it was important to be very clear. The girls and women who had been whose pictures had been downloaded, they were identified. There were geographical locations included in the information downloaded, and many of them were under the age of 18. And the court said, amongst other things, that the dissemination and sharing of these pictures of women and girls could mean lifelong abuse and affect their ability to find work in the future. So they wanted to be very strict in their interpretation. However, the Supreme Court instance did not feel that the Court of Appeal was correct in that they required the submission of underlying information on IP addresses. The assessment was that the valuation was incorrect in the Court of Appeal in terms of the assessment of the interest of both parties, and it was felt that that information was not, in fact, required to be provided in terms of a captive. And then I thought I'd tell you about the Get or Norwaco case. This was between Norwaco and Get for distribution and the potential requirement to pay for music rights which were included in the program Get distributed to its users. In the Supreme Court instance, Norwaco's requirement on redistribution was addressed, and there was a payment obligation on Norwaco, with dissenting opinion 4-1 in the court. A majority came to the conclusion that there was a requirement to declare this rebroadcasting. In 51, Webster clarifies that it is difficult to see and to determine in a situation with parallel distribution on several platforms, with cable, satellite, internet, etc., that one be indicated as the original one so that the broadcasting on other platforms will be rebroadcasting. She felt, if I've read it correctly, that it is very difficult to characterize parallel distribution as having one original one, but then if you look at 54, we see that to the extent that Get AS is distributing TV channels which contain protected works of art under copyright law, there is a requirement that Get AS will ensure that usage has been declared. There's a responsibility on Get AS and can be held responsible if the broadcasting company failed to comply with that obligation. I find that difficult to understand. If you look at paragraph 34 in the Norwegian law, the way I see it, it should be even more important to secure the compensation, the remuneration of rights holder for use by interpreting this in a technology-neutral manner rather than focusing on the formal aspects, because it can be a limitation of the copyright. It's very important to ensure that the users and copyright holders be provided better protection in that manner. And I've already, here is the next one, which is a follow-up to the Get case. 8th of June 2012 against Riks TV, a lack of declaration. The court in the Norwegian case would have then had to come to a conclusion where the case was only relevant if it couldn't be considered rebroadcasting. Tono went to course, but it didn't proceed. And the main proceedings took place after the Get case. Tono felt that Riks TV, as a national broadcaster, has a permanent obligation to declare the use of work under copyright. But there are various components here. They're saying that in the Supreme Court, they used this argument in the Norwegian case, but the first instance court says that it's not relevant to first require compensation from the broadcaster, and there's no indication of such obligation, nor is this something which is required under the existing legislation. I also have several other cases on dissemination and on blocking as well. Unfortunately, I've completely run out of time, so I'm going to have to conclude there. Thank you.